All right, I'm Jay Factor. I'm going to talk about the decision in the Jillard 2C58-4 case and the decision in the Cheeseman 2C58-4 case. This is the appeals court decision. And I think I'd like to start out by saying don't panic. We all knew we were going to lose the John Jillard and Mark Cheeseman case in New Jersey appeals court. I think everybody knew that. I think the argument is so different and so new that when we got a taste of it, we all thought there was a chance that the appeals court could actually see the logic in the argument. But again, we're facing 50 years of bad law. When I say that nicely. It's a scam. This whole permit process is a scam. It's been a scam since late 1969. The State Police Investigation Unit didn't want anybody to have handguns in public anymore. The prosecutors didn't want anyone to have handguns in public anymore. The attorney generals didn't want anyone to have handguns in public anymore. The scholarship and the law reviews all recommended that. The judges bought onto that. And today, we're going up against judges who, even though they've sworn to uphold the Constitution, don't believe in the Second Amendment. They think the founders were wrong, or they think that in 2018 it's not a relevant amendment to the Constitution, almost as if the militia clauses of Article 1, Section 8 no longer exist. The theory or the concept is that the police and the United States military will take care of us at all times. So let's go back to the beginning, the Cheeseman Jillard cases. What we were doing was getting the state on record as saying Heller 2821. That is to say, no more case-by-case determinations regarding the Second Amendment are allowed. That's what Heller 2821 says. They were either going to sever the Sicardi rule from the code, sever the code, 1354-2.4D-1, or they were going to have to come out and say, Heller 2821, no more case-by-case determinations, doesn't apply to them. Let me read this for you. Quote, this is from Jillard. Judicial quibbling aside, Heller did not hold, as Jillard suggests, that firearms regulations may not utilize subjective, case-by-case, justifiable need inquiries. Rather, the court mandated that any inquiry into the regulation itself must be conducted in accordance with traditional forms of judicial scrutiny. That's pretty interesting. That's from page 6 in Jillard. That's pretty interesting. Is that true? Yes and no. The Jillard court, a.k.a. Judges Simonelli and O'Connor, also in a bizarre move, copied Heller 2821, the core of the Jillard case, into their decision. 2821 reads, quote, it's from Heller. We know of no other enumerated constitutional right whose core protection has been subjected to a freestanding interest balancing approach. The very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. A constitutional guarantee subject to a future judge's assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think the scope too broad. That's from page 4 of Jillard's decision. That's a direct quote from 2821 in Heller. So remember, Judges Simonelli and O'Connor said, rather, the court mandated that any inquiry into the regulation itself must be conducted in accordance with traditional forms of judicial scrutiny. If 2821 was only talking about judicial scrutiny, why then would Heller say the hands of government, even the third branch of government? If you just meant judicial scrutiny or the third branch of government, why not just say the hands of the judiciary? If Heller only meant judicial scrutiny, Heller did not need to say hands of government. By enumerating even the third branch of government, that can only mean that the hands of government included the legislature and the executive. Am I wrong? You could read for yourself. Why would Heller then include the legislature 2 sentences later and say that, quote, this is a couple sentences down on Heller 2821 from what we just read, constitutional rights are enshrined with the scope they are understood to have when the people adopted them, whether or not future legislatures or, yes, even future judges think that scope is too broad. So why would Heller mention future legislatures if case-by-case determinations only apply to judicial scrutiny? Even the Heller dissent knew self-defense was, quote, the relevant standard of the Second Amendment applications. When you read Heller, Heller must be read at all times with the understanding that, quote, the core lawful purpose of the Second Amendment is self-defense, end quote. That's from page 28, 2018. It's really strange that New Jersey can't grasp that concept. New Jersey is still operating on a 1968 Burton v. Sills. There is no individual right to bear arms. Self-defense was not in the protective purpose of the Second Amendment, and the National Guard is now the militia of the Second Amendment. They're still operating under that premise. The Heller dissent reads, quote, if used for self-defense were the relative standard, why did the court not inquire into the suitability of a particular weapon for self-defensive purposes? That's at post 2845. But again, this is why you have to read all of Heller. The way the dissent read Heller was that self-defense is the relevant standard. Let me read you another quote from the dissent. I therefore begin to ask by asking a process-based question: how is a court to determine whether a particular firearm regulation, here the district restriction on handguns, is consistent with the Second Amendment? What kind of constitutional standard should the court use? How high a protective hurdle does the amendment erect? The standard is self-defense. New Jersey can't grasp that concept. They don't believe self-defense is within the protective scope of the Second Amendment. That's why they're clinging to urgent necessity, previous attacks, documented threats, and this special need. Let's move on to Cheeseman. Does anybody find it interesting that the Cheeseman decision only mentioned the Sicardi rule one time, and when they did, they put it in brackets? So Sicardi's in brackets, and then the R is in brackets for rule, as if I spelled the Sicardi rule wrong somehow when I wrote it. Capital S, capital R, emphasized as the Sicardi rule, because that's how they spelled it in Priest. And in Priest it says under the Sicardi rule, and they went on to explain previous attacks and documented threats. Anyway, Judges Gooden, Brown, and Rose used the presumption of constitutionality on us. When you read that in the Cheeseman decision, the presumption of constitutionality of the statute, how bizarre is that? We fully acquiesce that the statute 2C58-4 and the justifiable need phrase within the statute were constitutional. We overemphasize that. Judges Goodwin, Brown, and Rose ignore the argument, and they commingle the Sicardi rule with the statute, and they say, quote, beginning with the premise that statutes are presumed constitutional, in Patano, Sentence number 1 is completely independent from sentence number 2. They're beginning with the premise that statutes are presumed constitutional. Great. We didn't say it wasn't. Then they go on to tell their story about Pantano. In Pantano, and I have to stop here because Pantano was cited by the assistant prosecutor. Pantano is a ridiculous case. Pantano was a landscaper who carried apparently tens of thousands of dollars of cash for his payroll, and that's why he wanted a carry permit. Absolutely nothing to do with the cheeseman or the jillard argument. The prosecutor went to it. I countered and told him how silly it was to even use that as a citation in the reply brief. Somehow they're focused on Pantano because they love their own work, and they're getting away from the core of the cheeseman jillard argument, which is the Sicardi rule is determined on a case-by-case basis. Anyway, let me start over. Quote, beginning with the premise that statutes are presumed constitutional, in Pantano we hesitated to find a constitutional affirmity absent clear expression of the law from the United States Supreme Court, particularly where it would disturb settled law. We noted that federal district courts, including New Jersey's and other courts, have concluded that our state law governing permits to carry handguns does not burden any protected conduct under the Second Amendment, and a statute prohibiting carrying a handgun outside the home without a permit was not at odds with Heller or McDonald. Rather, Heller addressed only the right to bear arms in the home, and the language of Justice Scalia's majority opinion deliberately limited the scope of the right recognized to the home. End quote. Again, it has to be pointed out, we didn't challenge the statute, not one time. We spent an entire page explaining we weren't challenging the statute. They glossed right over that. So, in those paragraphs that I just read you, we must underline, quote, outside the home, end quote, in paragraph 2, and quote, in the home, end quote, and quote, limited scope of the right limited to the home, end quote, in paragraph 3. Judges Gu and Brown and Rose completely ignore page 45, completely ignore DC Code 4504 and 4506 in Heller. They ignore that Catano took place, quote, one night after leaving work. Catano found her ex-boyfriend waiting for her outside. Outside work in Catano is in public, outside the home. Go back and read Justice Alito's words in Catano at 1028 for yourself. Catano was an outside-the-home case and arrived at holding tasers under the protection of the Second Amendment by comparing them to modern handguns. Worse is the condensed reading of Heller. To say that Heller was an in-the-home case completely ignores D.C. Code Section 224504A and Section 224506. But these are the equivalent to New Jersey's 2C58-4 permit process and 2C39-5 unlawful possession of weapons statutes. Go to Heller in Google Scholar. Search 4504. Here's what comes up. Quote, wholly apart from that prohibition, no person may carry a handgun without a license, but the chief of police may issue licenses for a one-year period. See Section 224504A, 224506. That's from Heller, page 2788. Quote, the present suit involves challenges to 3 separate district firearms restrictions. The first requires a license from the district's chief of police in order to carry a pistol, i.e. a handgun, anywhere in the district. See DC Code, Section 224504A, 2001. See also Section 224501A, 224506. Because the district assures us that respondent could obtain such a license so long as he meets the statutory eligibility criteria, and because the respondent concedes that those criteria are facially constitutional, I, like the majority, see no need to address the constitutionality of the licensing requirement. See page 2818 and 2819. That's from Breyers to Stennett, 2853. So, The appeals court gave us traction. They admit two things. Heller recognizes the Second Amendment is an individual right, and McDonald applies the Second Amendment to New Jersey. But simultaneously, and this is bizarre, New Jersey then says Heller is an in-the-home case and simply ignore the bear arms language in the Second Amendment. Although they don't come out and admit it, what New Jersey is saying is that Heller turned the Second Amendment into the right to keep arms. The bear arms clause isn't in there anymore in New Jersey. And the right to keep arms is all that McDonald applied to New Jersey. And that the right to bear arms is stuck in Burton, which is akin to saying the right to bear arms is stuck in Trenton Purgatory. The other thing Judges Goodwin, Brown, and Rose gave us is that they believe the Sicardi rule is long-standing. That, to me, as a Second Amendment historian in New Jersey, is pure gold. It's simply not true. I've shown you repeatedly that the Sicardi rule from 1971, right, did not become part of the code until 1991. How do you miss the New Jersey Register? How do you miss the requirements of the Administrative Procedures Act? How do you miss the whole rulemaking process and then 20 years later end up in the code and consider that long-standing and presumptively lawful? Worse, Judges Goodwin, Brown, and Rose claim that the Sicardi rule is presumptively lawful, and that may just be the straw that broke the camel's back. The Sicardi rule was illegally designed by the investigation unit of the state police sometime in 1970, right? We know the cases that are showing after the gun control law of 1966, 2C58-4 permits, and this is where it gets a little confusing. They were called 2A151-44 permits prior to 1978, but let's just say carry permits were being awarded from 1960 all the way through 1966, 1967, 1968, 1969. It wasn't until 1970 that they started to deny these permits, but they were denying these permits to guys who had gotten permits from 1960 to 1969. So the proof is actually in the New Jersey court cases. Riley v. State is one where the doctors had gotten permits for the previous 9 years, and then all of a sudden they didn't give the doctors their carry permits anymore. Riley v. State comes out around the same, almost the same time as Sicardi. There's another case called In re Newman, where Richard Newman was a pharmacist and had a permit from 1961, 2, 3, 4, 5, 6, 7, 8, and they revoked his 69 permit. The New Jersey Supreme Court knew, and there's no other way to read it, the New Jersey Supreme Court knew it violated the Administrative Procedures Act. So this is what happened. In Sicardi, they concocted this internal policy of assignment judges. No one has ever seen that policy. It's not in the rules of the court. There is simply no public documentation, because they all wanted a plausible deniability to hide the paper trail. But again, judges were not acting as judges in 2C58-4 cases. They were acting as administrative agents. They are, in fact, crossing the watertight compartments of the separation of powers and acting in an executive capacity. That much is admitted by Sicardi and Priest. The last thing I want to address, Judges Goodwin, Brown, and Rose put this in their decision at end of page 7 into page 8. Thus, quote, let me go back, quote, thus here as in Pantano, we conclude that given the presumption of our law's constitutionality, the lack of clarity that the Supreme Court in Heller intended to extend the Second Amendment right to a state regulation of the right to carry outside the home in the Second and Third Circuit's explicit affirmation. 2C58-4's case-by-case schema requiring a showing of justifiable need withstands constitutional scrutiny post-Heller and its progeny. Very interesting statement, because in Priest, let me take you back before Priest, in Sicardi, the judges came out. There is nowhere that you read 2C58-4 or the gun control law itself that the judges are given any powers to come up with the Sicardi rule. Better said, the judges are given any rule-making powers. The only person who's allowed to make the rules in the administrative code for the issuance of permits is the Attorney General. That's in 2C58-2.6. The legislature gave that authority to the Attorney General. And somehow, in Sicardi and Priest, the New Jersey Supreme Court envisioned, because the legislature made them the administrative agent that issued the carry permit, that they had rulemaking powers for carry permits. As a historian, that is absolutely absurd. But what's more absurd is that they can find judicial rulemaking authority in 2C58-4, or let's say the gun control law, but they can't find a right to bear arms in public in Heller. All the cases that Heller cited, all the concealed carry cases, Andrews, Reed, Chandler, talking about the militia in the Revolution, talking about the Miller case and how the militia is a covered weapon, is designed to keep the militia going. They can't find a right to bear arms outside the home in Heller, but they can find the right for them to come up with rulemaking authority on how to hand out carry permits is absolutely ridiculous. And that's how you know how illegal, how preposterous this scam is. That's how you know how political this scam is. That's how you know that these judges don't believe in the Bill of Rights, that these judges don't believe in the Second Amendment. They think they're smarter than George Washington. They think they're smarter than Alexander Hamilton. They think they're smarter than Henry Knox. They think they're smarter than James Madison. Or they think that the Constitution itself is outmoded. And that's scary. That's scary. The 1924 law, the original need provision, came into effect as a way to stop bootleggers and organized criminals. What was happening is these guys were committing crimes, extortion, illegal liquor trade, many other criminal activities. And the cops knew these guys were doing the wrong thing. But for one reason or another, they couldn't arrest them. When they would stop these guys, they would always frisk them, and they would have concealed handguns on them. The easiest way to prevent illegal bootlegging, illegal criminal activity, was to take away their teeth. That's why they came up with the concealed carry law, that you had to go in front of a police chief. Because what it did is it forced any criminal who is regularly carrying a handgun to have to go to the police chief and get a permit. Obviously, the chief's not going to give a guy that he suspects of being a criminal a permit. And if not, he was subjecting himself to arrest. There was a lot of pressure from New York, from the Sullivan Law. There was a lot of articles in the New York Times that because we weren't doing anything comparable to the Sullivan Law, we are contributing to the organized crime in New York. But the reason that we did it was there was a massive, because we live on the water, a massive bootlegging and organized criminal problem going on during Prohibition. The judge was just there to make sure the police chief wasn't being bought off. That's what was happening prior to that. If you paid a judge $1,000, and to be honest with you, the stories that I'm reading, you were paying $20, $25 to get permits. If you're paying a guy who's making, $5,000 a year, $50 for a permit, he's giving it to you, and he's doing 4 or 5 of these permits a week. That guy's making more money selling permits than he was in his annual salary. That was going on. The other problem was in New York, which was in the papers all the time. You can search Judge Sewall, Sewall. I think he's from Oyster Point. The judges issued the permits in New York, and they were on the take. They were collecting the $5, $10, $15, $25 for the illegal permits. What happened in 1933 was there was a detective in the Monmouth County Prosecutor's Office, and quite frankly, the prosecutor, I think his name was Tooman, himself was involved. The detective in the prosecutor's office that handed out the gun permits, oddly enough, his name was Harry Crook. And there were some big names, the biggest of which was gangster Waxy Gordon, received a gun permit out of the Monmouth County Prosecutor's Office from Harry Crook. And obviously, nobody did an investigation on Waxy Gordon. There was a big shootout in a hotel in New Jersey. 3 terrible organized criminals were caught, all with handguns in that shooting, and they all produced carry permits from this detective. That presents a huge problem for us. Because of Waxy Gordon, the papers went crazy that all these organized criminals had carry permits. They called all the carry permits back in 33, and you had to go back in front of the court. The process then changed to you have to go before your local police chief. That would keep the guys from Brooklyn and New York out of getting permits in New Jersey. You had to go before your local police chief, and to make sure that he wasn't on the take, then you had to go to the judge. That was the concept that they came up with. Not that the judges were making the rules for the permits. It was just to make sure the judge wasn't on the take and the police chief wasn't on the take. Let's get back to the presumption from our law is constitutional and the lack of clarity in the Supreme Court in Heller intended to extend the Second Amendment to outside the home. I mean, that's so bold. I just told you Katana was an outside the home case. If you read Heller, they talk about carrying arms in case of confrontation. That's completely diametric to the Sicardi rule. But for us, the New Jersey Appeals Court in Cheeseman just said on paper that Heller's no more case-by-case determinations of the Second Amendment doesn't apply to New Jersey. That's pure gold moving forward. Let's get back to Gillard's page 8 real quick before I close this out. Judges Simonelli and O'Connor had this to say, quote, like the Second, Third, and Fourth Circuits that have previously upheld laws conditioning the issuance of carry permits on need, we found the state's interest sufficiently important and the fit between the need-based standard and the interest in order and safety in public places adequate to pass muster under the intermediate level of scrutiny. So let's underline we found an underlying quote, and the interest in order and safety in public places. That's clearly interest balancing. Even if the courts want to claim that case-by-case determinations doesn't apply to them, the law itself is interest balancing and is not permitted under Heller 2821. All right, so I'm going to close this out. It's a long fight to challenge 50 years of illegal gun carry permitting law. We knew this going in. I don't want anyone to think that I think that this is the only way to attack New Jersey. I don't think that. The reason that Mark and John and I are using no more case-by-case determinations is because we don't have the resources to re-argue all of Heller. And that's what New Jersey wants to do. They want to string you out, make you spend an enormous amount of money, and try to re-argue every point in Heller. And they want to cherry pick that long-standing prohibition, presumptively lawful prohibition in the home. That's what they want to do. And they want you, in essence, to have to refight everything, because when you do that, the fact that the law is not presumptively lawful, the fact that the law is not long-standing, gets glossed over. I believe, personally, justifiable need is a violation of the Second Amendment. I truly believe that. I'm acquiescing, Mark and John, we're acquiescing that 2C58-4 is constitutional because we think it's too difficult of a fight. And if you haven't applied for a carry permit and you haven't been in Superior Court, it is a revelation. You're talking about the Second Amendment and the right to keep and bear arms, and they're talking about Sicardi and Priest and Borinsky and now Wheeler. Apparently now Pantano. You can't fight them on the Second Amendment because they don't even want to go there. You have to, my thought is, you have to beat them at their own game. We've beaten them at their own game. Urgent necessity is clearly determined on a case-by-case basis. There's no other way to determine it. Your urgent necessity is different than my urgent necessity, which is different than Mark's urgent necessity, which is different than John's urgent necessity. Every one of those four applications is different. There is no standard. The legislature, which created justifiable need, which, let's face it, come on, it's synonymous with urgent necessity. I shouldn't say the legislature, but they didn't intend it to be decided on a case-by-case basis. They intended on it justifiable need to be the standard of lawful purpose. We've explained that before. We don't need to get into it. But let's assume that the government thinks that's what the legislature thought, that justifiable need is determined on a case-by-case basis. Really, that it's not the legislature. It's the investigation unit of the state police in late 1969, then the assignment judges in 71, then it's the entire judiciary in 1990. It's clearly the Attorney General's office. It's clearly the prosecutor's office. And I have stuff where the prosecutor's office admits they don't want anyone to carry handguns. I could post that. But Heller says the legislature can't make a rule, a law that's determined on a case-by-case basis. They don't want anyone to focus in on that. They don't want anyone to attack that fact, but 2C58-4 is interest balancing. We now have that on paper in the appeals court. The Cheeseman case is going to get interesting because there are steps we must take that we would probably prefer not to take to keep this paper trail going, to extend the timeline, to actually be able to move this to the next level. But the first series of downs has been run. New Jersey thinks it beat Cheeseman and Jillard because it denied them in appeals court, and normally those cases just go away. What they've done is they've given Cheeseman and Jillard their playbook. And now we know they don't think Heller 2821 case-by-case determinations apply to them. We know that they still think Heller's an in-the-home case. They don't admit that the Second Amendment exists outside the home, basically saying there is no bear arms clause. This case is going to get very, very interesting. And if you're New Jersey, it's not going away. It's not going away because of you guys that actually made it through 25 minutes of this video and donate to the Cheeseman-Jillard case. That war chest has been saved up. Mark and John used a few $100s of that money to file an appeals court, and that was it. I haven't taken a dime. That war chest is still there, growing every day. When counsel is hired, that war chest is going to pay for them to take this argument to the next level. Thank you.